Good afternoon, everybody. Welcome to the House Environment and Transportation Committee for November 19th, 2024. We were picking up on a briefing we were having a few weeks ago when we ran over with some of our other topics. So the Attorney General asked to reschedule so he could get on with his other work, which we were happy to do. So we welcome him here to talk about claims related to the Key Bridge collapse approximately in mid-March. Earlier this year, the Dolly crashed into the Key Bridge, causing it to collapse. About 6 months later, the Attorney General filed claims against Grace Ocean Private Limited and Synergy Marine Private Limited related to claims. And we are curious to hear what those claims are and how the litigation is going. And I will say, I think we were all happy to see in President Biden's emergency authorization yesterday, inclusion of additional funding for the Key Bridge, and we hope that continues on a bipartisan basis as we transition forward here. And with that, let me turn it over to the Attorney General, but just remind my colleagues, we'll do questions after the Attorney General and his team, who he can introduce, finish their presentation. And as usual, we'll use the raise hand function in order to recognize folks. So with that, Mr. Attorney General, thank you for being with us again.
Well, thank you, Mr. Chairman, and members of the committee. Thanks for having us, and thanks for your indulgence rescheduling this to this month from last month. And I know that you've been busy at work looking at a number of issues around in the port and other transportation environmental matters impacting and involving the state. So thanks for having us. And as you mentioned, Mr. Chairman, I am joined by the chief of my civil litigation division, Rob Scott, who will assume that role actually on January 1st, but is serving in that capacity today, and the one of my deputy attorneys general, Carolyn Petrocchi. So I wanted to take a few minutes to brief you on the status of the state's litigation to recover damages from this enormous harm caused by the collapse of the Francis Scott Key Bridge, as you mentioned, and we all have sort of emblazoned in our memory that happened on March 26th of 2024. I do want to first thank the members of this committee and the General Assembly, and working with the governor and your leadership in responding to the tragedy. It was your rapid response that enacted the Port Act. Only 2 weeks after the collapse of the bridge, it provided economic relief for thousands of workers and affected businesses. It was a governor's rapid response to the crisis that cleared the shipping channel and allowed the port to fully reopen in less than 3 months. And in record time, the Maryland Transportation Authority selected a firm to begin designing a new bridge. And while all this was going on, the Office of the Attorney General, in conjunction with our assistant counsel or outside counsel, we've been working to investigate and to begin the legal proceedings to hold accountable those responsible for the destruction of the bridge. So to that end, on September 24th, we filed Maryland's claims against what we call the vessel interests, and that consists of the owner and operator of the MV Dolly, Grace Ocean Private Limited, the owner, and the operator manager is Synergy Marine. And our claims will show that their abject failures are what caused this tragedy and the widespread harms that resulted from it. We are all painfully aware those harms included a 3-month closure of the Port of Baltimore, economic and environmental harm to communities across the state, and most tragically, the lost lives of 6 Marylanders. The state and its taxpayers should not, and they will not, pay for these harms, and that's what the litigation is all about. So our complaint alleges a total of 13 claims on behalf of the state, the Maryland Transportation Authority, the Maryland Department of the Environment, and the Maryland Port Administration, all of whom or which seek to hold liable the vessel interests. We allege that their gross negligence led to the unseaworthiness, and that's the key term here, the unseaworthiness of the vessel when it sailed that morning. Our investigation shows that the day before the collision, the Dolly's electrical system failed twice, failures that the ship's owner and operator could have and should have fixed prior to the departure to avoid this tragedy. They failed even to inform the U.S. Coast Guard, as the law required, or to warn the pilots who boarded the Dolly to help it leave the Port of Baltimore. Within minutes of leaving its berth, and we know how this unfolded, we've all seen this, the ship once again lost power, which in turn made it lose propulsion and steering capabilities. Ships like the Dolly are supposed to be equipped with backup systems that make sure the vessel doesn't lose power or steering capabilities, particularly at critical moments like when they're approaching a bridge. But because of the stunning mismanagement, and that's what we'll show, mismanagement, disinterest, and incompetence of the owner and operator of the Dolly, those backup systems failed. And this and other failures resulted in one of the most catastrophic and preventable maritime disasters in Maryland history. So our complaint also alleges additional claims for liability, including, and I mentioned, unseaworthiness, and that's under maritime law, ordinary negligence, public nuisance, violations of state and federal environmental laws, and breach of maritime contract or the port tariff, the contract between the vessel interests and the Port of Baltimore. Pursuant to these causes of action, we will seek to recover for all of the harms caused by the failures of the Dolly's owner and operator, and that they will include, I'm anticipating that one of the questions will be, how much are the damages? And I can tell you up front that a specific dollar amount we are not able to provide you today. But what are the components of the damage? It will be the cost of, the removal costs for the massive cost to replace the bridge, the lost toll revenues until the bridge is reopened in several years, monies and time spent by numerous state agencies to respond to the casualty, to perform salvage operations, and to try to mitigate the impact to the welfare and safety of Maryland residents. There'll be environmental damage claims to state waters and to the state's air quality due to the Dolly's release and threatened release of pollutants and debris into the Patapsco River, and the significant increase in vehicle mileage necessitated by the loss of the bridge. The damages will also include increased wear and tear on roads, highways, and other infrastructure, revenue and taxes loss, and other forms of economic loss that flow from the Dolly's destruction of the bridge and the resulting closure of the channel providing access to the Port of Baltimore. And in addition to our complaint, more than 40 other parties have filed their own claims against the ship owner and operator, including the federal government, Baltimore City, business owners, and the families of the workers who were killed. On November 7th, earlier this month, the federal district court, that's Judge Bredar, entered a scheduling order, setting a trial date for June 1st of 2026. And that's a trial on the ship owner's claim that its liability to the state and other claimants is limited under maritime law to the value of the ship and cargo, and that's approximately $43 million. We are going to work tirelessly to defeat this attempt by the ship owner to limit its liability. Now, discovery in the case is underway, and that's going to continue until February of 2026. While the legal process will take time, we'll do everything that we can not to delay and to move this along expeditiously, because we, like you, believe that Marylanders deserve compensation and accountability for the failures of Grace and Synergy as soon as possible. So with that, Mr. Chairman, I and my team will be happy to answer any questions that you have.
Thank you. As my colleagues are raising hands, let me ask the first question, Mr. Attorney General. One of the things we heard in the immediate aftermath, of course, was President Biden committing to cover 100% of the bridge replacement, I think welcomed by everybody on this call. And then not for Marylanders, but nationally, some folks responded to that and said, well, that's silly. We should be having the responsible parties pay. So I just want to confirm, and this may be more of a question for the Transportation Authority, but your understanding would be we would not be over recovering. If we recovered funds for bridge replacement, that would go back to the federal government for the cost they gave us for replacing the bridge. Is that correct?
That's correct. So, I know Governor Moore, the congressional delegation, they're working with members on Capitol Hill to have the federal government pay for 100% of the replacement costs of the bridge. The question, as you raised, has been raised on Capitol Hill. The governor and his team, with our support, has been able to answer that question pretty definitively, that any recoveries that we have from this litigation will be used to offset the costs to the federal government. It's often like when you have your own insurance for damages that you may suffer, and then if you're in court and you recover, your insurance company often says, hey, we need to be reimbursed for that as well. So it's almost like subrogation back to the federal government. But the short answer is yes, the federal government, the federal taxpayers, which include Marylanders, will be reimbursed upon the recovery of damages in this litigation.
So just to be clear, your litigation does not say we don't need the federal government assistance, just as the federal government assistance doesn't say you don't need to litigate.
Exactly. And, you know, I at the rate at which the procurement is happening and the MDTA is moving forward with that process, you know, it's not unreasonable to imagine a scenario where that bridge will be completed before the litigation is over. So to delay working with or pressing the federal government to fund the bridge, waiting for the litigation to conclude, I think that would just exacerbate the damages to Maryland, the environmental damages, the lost revenues, tax revenues, toll revenues. So yes, we need to work with the federal government, get full funding, build the bridge, and then we'll certainly wrap up our litigation as soon as possible.
Thank you. Let me turn to my colleagues, Delegate Foley.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for being here today and giving us this briefing. And I am really glad that the state of Maryland is being aggressive about pursuing damages in this case. My question is, given what you said about maritime law limiting damages to the cargo and the ship, how common is this kind of litigation in these situations? Have other states done this? Have other governments done this? And what has been, you know, the track record on a massive suit like this?
Sure, this is a common occurrence when you have a vessel that causes damage. The vessel interest will always seek to limit their liability to the value of the vessel, its cargo, minus any depreciation or losses or damages to the ship and its cargo. And you know, let me, before I answer the question, let me be careful to caveat that with almost like when you talk about the stock market, past performance is no guarantee of future performance. But the numbers are available, and roughly 2/3, if not slightly more, of the challenges like Maryland is bringing to defeat the limitation, anywhere from 2/3 to slightly more, are successful. But every case is different. Every case is different, and it's important that we are able to demonstrate, as we set forth in our response or in our complaint, that the vessel interests knew or should have known that the ship was unseaworthy. So we focus a great deal of our investigation on those issues that speak to what the vessel interests, the owners, the operator, managers should have known about that ship, and in fact, what we are seeing, what they did know about the ship.
Thank you. Thank you again.
Thank you, Delegate Holmes.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for all your assistance in all of this. And as a veteran of the Search and Rescue Unit of the U.S. Coast Guard, I want to extend my thank you out to them as well in their efforts for this opportunity, for this situation that took place. And the question that I have, Mr. Attorney General, is when the ship owners and their representatives file for bankruptcy, when they file for bankruptcy, because I'm sure they are, how would that affect our claims? And what happens next after they file for bankruptcy, Mr. Attorney General?
Sure. So they have not filed for bankruptcy right now. They filed to limit their liability. Keep in mind, and I can't speak to the finances of the vessel interest, okay? But this is a global shipping company. Upon our information and belief, they have certainly sufficient resources, including insurance, to cover these types of calamities. But we haven't crossed that bridge as yet. Right now, we're looking to defeat the limitation of liability action. And if and when the vessel interests were to try to limit their liability further in bankruptcy, then we would cross that bridge at that time. And we have experience in that as well.
Thank you, sir.
Dr. Healy.
Hello, and thank you so much for being here today to explain some of these things. I'm glad you answered the question about bankruptcy because that was one of my concerns. The other question I have, you had listed a lot of specific impacts that this disaster has had on the people and the state of Maryland. And my question is about if the federal government, what they mean by 100%, would they make us completely whole for all of those itemized things? And if not, would we be able to keep some of the reimbursement for those specific things? I'm thinking about things like the environmental damage or the damage to the local economy of businesses and so forth.
So let me answer it this way. And as has already been reported in the news, the federal government has been in settlement negotiations with the vessel interest around, I think the number that is out there, and we're not working with the federal government on that. So my information that I'm providing you is essentially restating what I, like you, have seen in open news sources, about a little over $100 million that the federal government is seeking to settle with the vessel interest. And that primarily focuses on the cost to the federal government to reopen the channel. And the federal government's able to enter into that settlement, and the vessel interests are willing to do that because that doesn't fall under the limitation of liability action. It's a separate set of laws that govern that. There's no limitation. The vessel interests recognize that they have liabilities, so they're entering into a settlement with the government. When we're looking at everything outside of what the government is settling for, you can expect that the U.S. government will want to be reimbursed from at the conclusion of our action, whether our action concludes with settlement or goes to a jury. You can expect that the federal government would want to recover all of its expenses, right? So if the federal government if the federal government pays 100% for the replacement cost of the bridge, they're going to want that 100% back. If there are any other costs associated with costs to the U.S. government, they no doubt will work with Maryland to recover those damages as well. But there are other damages that are unique and purely Maryland, like our lost revenues, tax revenues, the lost toll revenues, the impact on our environment, both the water, which our Department of Environment has responded to, our air, because of the additional, and this is not, I mean, this is real, right? I mean, the increased traffic because of the loss of the Key Bridge is significant, and it has been and will continue to have impacts on our air quality. Those are Maryland damages. So Maryland, after that the settlement or the conclusion at trial of this case, we can expect that the federal government's going to want to be reimbursed for its damages, recover its damages. And we will work with them on that. But I am confident that Maryland is going to have, from the settlement and or recovery after trial, will have a compensation that will offset our damages. Whether it's 100% or not, this is what litigation is all about.
Okay, thank you so much. It's very helpful.
Delegate Celebrity, do you have a question? You're good? Okay. Delegate Ruth? Oh.
Thank you, Mr. Chair. Thank you, Mr. Attorney General, for your work on this. Do you would you have the results of the Justice Department investigation and their findings available to you And do you anticipate any issues with the change in administration in getting that information?
So I'll answer it this way. Certainly any publicly available documents, and some are available and some aren't, we can use. I'll say that as in all litigation, when parties have a common interest, that parties enter into a common interest agreement where they can share information. Okay, when we're deposing witnesses or making document requests for efficiency, often one request is made and shared by all the parties. So you're not, I mentioned 40 claimants, so you don't have someone from the vessel interest, let's say someone from the owner, operator having to undergo 40 different interrogatories or depositions, I should say, or responding with 40 different sets of documents. So in these common interest agreements, and this is true whether you're a defendant or a plaintiff, there is information sharing. So to the extent that we have common interests with the U.S. government, we will be in common interest agreements and share whatever information we can pursuant to those agreements.
Thank you.
Delegate Stewart.
Thank you, Mr. Chair. Well, thank you, Mr. Attorney General, for coming and for taking the fight to these, companies that clearly were, in my view, grossly negligent and clearly caused a lot of harm to folks that we represent and the broader economy as a whole. My question really had to do with kind of what the current legal fight is about, and it sounds like it's about this, Limitation of Liability Act of 1851, which, in my opinion, seems like kind of anachronistic, right? Doesn't it like predate the idea of like limited liability corporations? But that's not my question. My actual question is the current dispute is sort of like the first round of this before we can kind of get to a good settlement number or whatever. Is the first round basically about whether or not people high enough on the corporate chain had that like privity or knowledge requirement in the act to trigger the liability? Is that kind of like what the fight is about right now?
Yeah, so the first round is, the limitation of liability. There are legal standards that have to be met in order to overcome those limitations. And those standards really look at the knowledge and conduct of the vessel interest. Not so
like
much
the higher ups, right? Like the higher
not
up
so
corporate
much the crew. Exactly.
Right.
Sort of like that port side interest, not so much the crew. And I'm not making a statement right now about the negligence or absence thereof of the crew. So I'm not answering that. I'm not addressing that. But to address your question, the focus is on the owners and operators and managers. Okay, what they knew about the vessel and its unseaworthiness.
Perfect. That's helpful. Thank you.
Great. Are there any other questions from members of the committee? Okay, well, Mr. Attorney General, I think we all wish you good luck and good hunting with this litigation. Hope you'll continue to provide updates as we go along here.
Thank you, Mr. Chairman. Will do. I wish everyone a safe, healthy, and happy end of year period and holidays, however you're celebrating them. And we'll see you in January. It's right around the corner.
Sure.
Take care.
Thank you all very much. Have a great afternoon. We are adjourned.
Thank you so much.